Welcome to Podkey Left and Right, where today's rulings and power plays actually get pressure tested. A lot of this week turns on the same question: who gets to decide and who gets insulated from politics? The court gave presidents more direct control in some places, drew harder constitutional lines in others, and left a few very awkward exceptions sitting in the middle. The biggest structural ruling may be the one on presidential removal power. The court said presidents can fire leaders of most independent agencies without a good cause limit, which cuts straight through the old Humphreys executor framework and pulls agencies like the FTC, EEOC, and NLRB closer to the White House. Supporters call that a restoration of Article 2 accountability, and there is a real argument there. If agencies exercise executive power, voters should be able to trace responsibility back to an elected president. But the trade-off is just as real. Independence existed because Congress wanted some regulators buffered from immediate partisan pressure, especially where technical expertise and long-time horizons matter. The oddest part is the Fed carve-out. If independence is constitutionally suspect, why is monetary policy special? If independence is sometimes justified, why stop there? That exception may be practical, because markets hate political control of interest rates, but as legal logic, it invites more fights than it settles. On birthright citizenship, the court reportedly took a much clearer line. If you're born on US soil, the 14th Amendment covers you. That matters because the narrower reading of subject to the jurisdiction was never just an academic argument. It would have changed legal status for a very large number of children, with estimates in the hundreds of thousands of births a year potentially affected. The dissent's claim is that allegiance and domicile should matter more than mere geography. The problem is historical and practical. The dominant legal tradition has treated US birth as the rule, with narrow exceptions like diplomats, and a different rule would create a class of US-born people whose status depends on parental paperwork at birth. That's administratively messy and politically explosive. So if people say this issue is still one election away from reversal, that's overstated. Short of a constitutional amendment, the legal path gets very steep, very fast. The transgender athlete ruling is one of those cases where scale, symbolism, and doctrine are all getting mixed together. The court upheld state bans on transgender girls competing on female teams and read Title IX's reference to sex as biological sex in this setting. If you're evaluating the ruling, one key point is that the legal question is narrower than the cultural argument around it. The court is deciding what states may do, not resolving every scientific, ethical, or school-level dispute. Another missing piece is scale. Claims range from a tiny number of elite cases to much larger estimates in high school sports, and policy arguments often depend on whichever number best serves the speaker. That doesn't make the fairness debate fake. It means lawmakers are making rules under conditions of high symbolism and weak measurement, which is a recipe for fragmented policy and permanent litigation. The Mississippi absentee ballot case looks small, but it matters because election law often turns on administrative details that later get turned into legitimacy fights. The court let ballots postmarked by Election Day count if they arrive within 5 business days. Alito's dissent says Election Day should mean 1 day period and that anything else invites distrust. The majority's logic is more about state discretion and practical administration, especially when mail systems don't operate on clean political timelines. The stronger legal argument appears to be that states have room to define how lawful votes are processed, but the political downside is obvious. Every delayed count becomes fodder for suspicion, even when the rule was public from the start. 2 immigration rulings pushed in the same direction: more executive control, less judicial recourse, and tighter statutory readings for migrants. On temporary protected status, the court limited review of terminations, reinforcing that TPS is temporary in law, even when in human terms people have built entire lives around it. On asylum, the court read arrival, narrowly enough that people waiting in Mexico did not count as having arrived in the United States for asylum purposes. The government's argument is that looser access creates incentives for forum shopping, smuggling, and unmanaged entry. Critics answer that formal line drawing can produce humanitarian absurdities, where physical proximity and danger are obvious, but legal access vanishes. Both points can be true at once, which is why these rulings will be judged as much by downstream human consequences as by statutory neatness. One place the court was, notably privacy protective, was geofence warrants. It said broad grabs of everyone's cell location data in an area trigger Fourth Amendment concerns, which matters enormously because location history can reveal visits to clinics, doctors, religious spaces, protests, and basically the map of a person's private life. That ruling cuts against the habit of treating digital data as frictionless evidence just because companies happen to hold it. By contrast, on campaign finance, the court struck limits on coordination between parties and candidates, extending the logic that spending is protected political expression. The tension is hard to miss. The court is skeptical of broad state access to private data, but often skeptical of broad state limits on political money too. The unresolved question is whether that combination protects liberty evenly or mostly empowers the actors who already have the most resources. The Roundup ruling is a classic preemption fight with huge real-world stakes. The court said federal pesticide law preempts state law requirements for cancer warnings on glyphosate products, effectively giving EPA labeling judgments priority and cutting back failure to warn suits. If you like uniform national regulation, that makes sense. Companies shouldn't face 50 contradictory warning systems on one label. If you care about tort law as a backstop, when regulators move too slowly or too favorably toward industry, it's a major loss. State lawsuits are often how buried risk arguments force public disclosure. So the practical result is not just legal tidiness, it shifts power away from juries and plaintiffs' lawyers and back toward federal agencies, which sounds cleaner unless you think the agency itself may be wrong. A quieter but revealing political story is the mismatch between governing and messaging. Congress passed a bipartisan housing bill meant to boost supply and limit investor purchases, while local governments like New York are still using rent freezes and rent controls to deliver immediate relief. Those are two very different theories of the housing problem. One says build more and curb speculative concentration. The other says tenants need protection now, even if economists warn about supply distortions later. Neither side gets to skip the trade-off. Supply measures take time and often run into local vetoes. Rent controls can help existing tenants while making future construction less attractive. What's politically interesting is that housing, unlike a lot of culture war material, forces both parties to confront scarcity rather than just posture about values. Inside the Democratic coalition, progressive primary wins and confrontations over Gaza are showing that the party's internal argument is not a sideshow anymore. For some activists, Israel policy has become a baseline moral test. For centrists, that kind of purity politics can fracture coalitions and hand power to opponents. Layer on reports of influencer contracts and foreign-funded messaging campaigns, and the information environment gets even murkier. The core issue is disclosure. Persuasion is normal in politics. Hidden sponsorship, especially from foreign interests, changes how listeners should evaluate the message. That doesn't mean every viral narrative is an operation. It means audiences need a better habit of asking who benefits, who paid, and what evidence exists before outrage hardens into certainty. The Ukraine war keeps demonstrating how fast military technology diffuses once a conflict becomes a live laboratory. Drones with AI-assisted targeting, 3D printed parts, and commercial satellite links have changed what relatively cheap systems can do on a battlefield. The immediate argument is about helping Ukraine defend itself. The second-order question is what happens when those methods, supply chains, and technical skills spread well beyond this war. That concern is not alarmism. We've seen before that wartime tools rarely stay neatly contained. The hard part is that the same capabilities that make smaller states more resilient can also make non-state violence cheaper and more scalable. That's the through line this week. The fight over who holds power, who checks it, and which institutions get treated as neutral when they're anything but. Thanks for listening to Podkey Left and Right. This episode was generated by Podkey. Create your own at podkey.fm.